Have you ever looked at the partner visa requirements and thought, well, that's it, we have absolutely no chance? Most people think the Department of Home Affairs is looking for a fairy tale. You know the type, a couple with a joint lease, a shared bank account, happy photos at Christmas, and a spotless history. Perfect. But real life isn't a fairy tale. Life gets messy. Here is the question we're tackling today. What happens if your sponsor has a criminal record? And what happens if you can't live together because your partner is currently in prison? We recently took on a case exactly like this. Everyone told them it was hopeless, but today I'm going to share how we turned that hopeless situation into a visa grant. Before we dive into the details, I need to give a quick disclaimer. The information in this video is for general information only and is not legal advice. Immigration laws change and every single situation is different, especially with character issues. If you're in a tricky spot, you really need to get personalized advice for your specific circumstances. So let's look at the facts of this case. We had a client from France. She was on her third working holiday visa, doing everything right. Working in regional Australia, ticking all the boxes. She met her Australian partner and they built a genuine connection. But her partner, the sponsor, had a difficult past. He had a long history of offenses. We're talking theft, trespassing, and drug-related issues. He was working hard to turn his life around, attending counseling, and really trying. But then his past caught up with him. During their relationship, he was sentenced to 18 months in prison. So here is the couple's reality. 1. A sponsor with a significant criminal history. 2. A couple that cannot physically live together because one of them is in jail. Most people would look at this and walk away, but we decided to look at the law, not just the assumptions. Let's break down the first big fear, the criminal record. There is some common belief that if the sponsor has a criminal record, they are automatically banned from sponsoring a partner. That's actually not true. It's much more complicated than that. The department is primarily looking for what they call relevant offenses and registrable offenses. Registrable offenses usually relate to child protection and sex offenses. This is a very high bar and strictly enforced to protect children. Relevant offenses generally include violence, stalking, harassment, or weapons. If the sponsor has a significant record, usually 12 months or more of imprisonment related to these specific types of violence, that is where the problem lies. When we analyzed our client's sponsor, his list of offenses was long. Stealing, drugs, trespassing. It looked really bad on paper, but none of them fell under the legal definition of a relevant offense involving violence against a person. And there were no children involved in the application. So legally, he was not barred from being a sponsor. That was our first win. Then came the second hurdle, the living together requirement. The law says you must live together or not live apart on a permanent basis. That word permanent is the key. We had to prove that his time in prison was a temporary separation. But you can't just say it. You have to prove the relationship is still alive while you're apart. In this case study, the applicant didn't just wait around. She stepped up. She visited him every single time she was allowed. She managed his finances and paid his bills while he was inside. She even supported his child from a previous relationship. We used this. We argued that this separation wasn't a weakness. It was actually the ultimate proof of their commitment. Staying by someone's side through a prison sentence shows a level of dedication that a shared electricity bill never could. So what happened? We prepared a massive submission. We attacked the character issue with precise legal arguments showing his offenses didn't meet the bar for refusal. And we built a narrative showing that their separation was temporary and their bond was unbreakable. The department accepted our submissions. The partner visa was granted. While the paperwork was processing, the sponsor was released on parole, and they were able to restart their lives together in Australia without the fear of her having to leave. So why am I sharing this information? Because I want you to know that difficult doesn't always mean impossible. If you just read the checklist online, this couple failed. But when you understand how the migration regulations actually work, specifically around character tests and temporary separation, you find pathways that others miss. It's about telling your story within the framework of the law. It's about knowing which details matter to the case officer and which ones don't. I've spent over 8 years working exclusively in Australian migration law, and I've seen how scary this process can be when your life doesn't fit a neat little box. At Flow Migration Law, we don't shy away from the complex cases. We look at the specific details of your life to find a way forward. If your partner visa situation keeps you up at night, or you're worried about a sponsor's history, let's have a chat. You can book a consultation with me directly through the link in the description box below. Let's see where you stand. Thank you for watching, and I'll see you in the next video.